So there will be item number 1.
Revision petition is allowed.
Item 2.
The criminal miscellaneous case is allowed, and the entire prosecution against the petitioner is set aside.
So grateful. That's
Bill paying of 4/1 of 2025 matter. Here is magistrate type of offense matter. On 12/5/2025 matter, you will see specific item today matter. In this case, I file an IMI.
I have told
No,
you
I
yesterday
have-
also. I told you yesterday also. I can't help it because I understand your problem, but the you also must understand my. I can't give all memo. I'll just check it up personally. I'll check it. You please give all memos. I'll check it up personally. I understand. Same problem maybe. I'll just check it personally. Vacation as it is, you can move.
No specific order. Put up on one move, nothing but
See, the problem is unless it is listed before me, I can't pass the order.
Others are not coming. We have come. 307 is very simple.
I understand, but unless it is listed before my court, how can I make the orders?
Your lordship's order.
I'll pass on to the registry to see that whichever is possible, get it listed.
Your
Get it
lordship's
listed
order.
tomorrow.
I have
for magistrate.
Just give it to the registry for any matter which is possible to be listed before my court, list it tomorrow.
For magistrate type interim bail file again.
ଆପଣ ତ ପୁରା ମ୍ୟାଟର ଆର୍ଗୁ କରିସାରିଲେଣି କୁହନ୍ତୁ
ଛୁଟିଟା ହେଇଯାଉଛି ଆଜ୍ଞା ଛୁଟି ଆମେ
I know let us understand what.
କିଛି ଖୁସି ହବ ଆଜ୍ଞା
Deep loveless.
Madam, this is not an assigned bench. Only the fresh matters are being listed. The matters which are listed, I am disposing on. It has to go to the assigned bench. You go to assigned bench. Mention. Don't waste time here. It will not be listed. Unless it is listed, how can I pass an order? I can't pass an order on the memo. Huh? That request you can make it to the assigned bench for vacation. Vacation bench. Yes. Let us start. Why 50? First modification. Yes. Yes. What? Huh?
Schedule. Correction to schedule.
I don't know. What is the modification?
Schedule of members.
Application. Yes. Which application? I number? Flag?
Like D.
Flag?
D. Yes.
D. Okay. What does it want? What does he want? Where the confusion? These two correct, modify the order. Also pass. I don't know where is the schedule. I don't get the schedule. There is no schedule. Schedule is schedule. Quoted paragraph 1 of the order dated so following section 54 506 34. Modify as per the schedule. Modify. Okay. Next.
51.
May I please, Lord?
Yes, tell me.
My Lord, extension and modification of order date 7/5.
What modification?
Modification meantime the case are transfer from.
Sorry?
Case was transferred from Kendrapada to Kotamde.
Kendrapada Kontabadi Chansi, na? Kendrapada to Kontabanji. Where is that? Now it is pending before
paper additional
Hon'Ble.
additional district session just Hon'Ble.
Pending before Hon'Ble court. It is Kendrapada court para number 3. In view of the confusion, petitioner did not appear before the court, hence the 15 days further extension is granted. 15 days count for the court. आज के तरीके ला 3 steps. 3 steps को कर दिया. First June कर दिया. ठीक है.
I know that 30 June 50 to 50
Correction करके correction. कंटामंजी same कंटामंजी.
Contamanji no sir. Kendrapada to Hon'Ble.
Pottamundai second time.
My lord, it may be 30 June because Chutti has
15 days I am giving.
my lord, up to 30.
Criminal courts are not closed. You can go and do it. Yes.
54, my lord, I am praying for extension of time, my lord,
Extension of time.
to surrender.
NBW cancel.
Yes, my lord, already granted, my lord. My lord.
NBW matter.
Yes, my lord.
Okay. Extended till we first of
55 and 56 is same.
55, 56 for the first of June.
Okay.
No further extension. Yes.
57. Please, perhaps. Well, it's flag D is a modification application. There are two small modifications.
Flag D.
Flag D, my lords. Flag D.
D for Delhi.
D for Delhi, my lords.
Yes.
The order, my lords, starts at page 11. Para 3, my lords.
Yes.
My lords, may I read? On perusal of contents of the application would reveal that exhibit VR3 has been forwarded to CFSL and the CFSL report obtained thus has been left out inadvertently. My lords, actually it is the sample voice collection and the...
Three.
Please, my lords, para 3.
CFSL report obtained. That's
The CFSL report is on record. What has been left out is the sample voice collection and the sealing memorandum, which my lords have recorded at page 12. The page before.
So then you want that the report obtained thus has been left out.
Please, my lords,
After that, what do you want?
The modification that we seek is that in place of that, it should be VR3 and related documents such as voice sample and sealing memorandum, cover letters, witness statements were left out to form part of the charge sheet. That is the
the CBI matter.
Yeah, the CBI matter.
I have to issue notice. Modification.
Modification. My lords,
I just issue notice. Huh?
Please, my lords.
Issue notice. Yes.
Yes. My lords,
Change of
my lords, if a returnable date may be, because the lower court.
18th June.
18th.
Reopening.
I am grateful, my lords.
Change कर दो. ठीक. Next.
59.
कौन सा type हो? Flag C. What type of? What mistake? Flag C.
GR केस नंबर टा भूल गई
चेंज कर दो.
केस 4
ठीक है.
प्रेयर
ओके.
GR केस नंबर 9 जगह 6 ही
नो दैट प्रोजेक्ट. यस.
GR केस नंबर 7 भाई 24 जगह 23
देखिए दो. ठीक है. नेक्स्ट.
60
यस सर.
60, correction of name and name of the petitioner's father.
What is the
That
name
was-
of petitioner father?
I have written Manoranjan Mishra, that is Manoranjan Das.
You, in the petition you have written Hon'Ble Mishra.
Yes, my lord.
Hon'Ble Mishra. Then the petition you have changed or not order.
Well,
Order is correct.
Yes, my lord.
You want.
I want modification Manoranjan in place of Manoranjan Mishra, it's Manoranjan Das.
Since the petition and the name of the petitioner, father's name of the petitioner has been written as Hon'Ble Mishra. Therefore, in the order dated 8/4/2024, but in the order there is no name is mentioned. So therefore, the
Cost
petitioner
title.
seeks to amend the cost title
And the age.
changing the name of Hon'Ble Mishra. to
Petitioner's age was also written 28 in place of 36, my lord.
age भी कर दिया. ठीक है. Okay, next.
61.
And my lord, extension of time, my lord.
Extension till the first of August. No further extension. Yes. File it.
61 extension of time.
Extension of time.
6 weeks may be given, my lord.
February February, I had given you time
Yes, ma'am.
to appear before court by March.
Yes.
Today we are in May. You are moving this application. See, first you will go and no further extensions shall be given.
62,
Extension time कर दो, no further extension shall be.
63,
ठीक है, otherwise again 15 दिन कर दो, सब काम करा. Yes,
63, 63, no, only extension of time, my lord.
same, huh? 15 June. Yes.
64, 64 also same. 65,
65, may I please, further extension of 4 weeks time for surrender, my lordship.
Not 4 weeks, same. No
Three-
change. For
3 weeks, my lordship.
15. Yes.
Obliged, my lordship.
6,
Item 66. Earlier, my lord, I have filed one bail application in which I was granted bail. And only because I have some antecedent, I was unable to surrender, for which I have filed this CRLMC for a first half, second half order. On the date of listing, my lord, as I was engaged in another court, it was passed over. And at 12:15, I have mentioned before your lordship, and your lordship has asked me to send your junior. I will pass first half.
I don't know what transfer.
But whether she has disclosed anything or not,
what
first half, second half, that order may be recalled, first half, second half,
which order I did?
15:4, my lord.
15-4.
Yes.
What have I said there?
My lord, to obey the earlier order passed and to
If there is
surrender.
an order you have to pass. See,
First half,
coordinate
second half.
bench order has passed some order. You have to comply that order.
Because I have antecedent, all the person, those who have
Then
antecedent,
you have to get that order modified. I can't help it.
said Mona Kurchandi only out for it.
I have only said that you have obtained an order, go and comply that order.
Because of
How can I modify the order of the coordinate bench?
no, that may not be modified.
Exactly, you are asking.
Your lordship only say
Directly, exactly, you are asking the same thing, but I can't modify it.
379 offense, my lord.
See my limitations. I understand your problem, but what to do? You tell me the solutions. I'll issue notice, you tell me the solution. 18th I put it. Oh, issue notice, lease it on 18th. Then you tell me the solution. What to do?
No, your lordship may not press.
I'm issuing notice, let us hear. It may, some solution may come out. We don't know.
Till then, not to arrest.
No, that I'll not. That I'll not do. I'm just
Only first
issuing
half,
notice,
second
let
half.
us see. 18th.
Because the person, those who are
I know you have a problem, but what to
Yes.
do? You have burned your finger by obtaining that order. 19th, 19th of June, issue notice. Yes.
67,
May I please, your lordship?
Yes.
Here, your lordship, we have prayer for the modification of your lordship's order dated 16/4/2025. Your lordship.
What modification, sir?
Your lordship, there, your lordship allowed the petitioner's account defreezing, subject to payment, subject to furnishing a bank guarantee of rupees 2 crore. Your lordship. But as the account has been freezed, your lordship, so we cannot furnish the bank guarantee. So we have prayed for modification to property sale. Last occasion, it was kept for instruction. Objection.
That is, he's asking for the modification of order to instead cash security. He wants to see the proportion on the ground that the account has been frozen. Therefore, the lordship may consider that. No objection that is between court and the petitioner.
But these are the consent of, right? What do you say?
Lots of considerable.
No, you have to,
Because that condition was imposed by the Supreme Court. Now they are saying that they cannot disclose whether they frozen up that accounts. We have written the authority consent for instruction, but as yet we have not received any instruction.
get the instruction, because see, what I remember is, when the matter was argued, Mr. Ponda has very categorically stated that yes, I will give bank guarantee. Therefore, I passed that order. I have not recorded the consent, but I remember. And on the basis of your statement, I passed that order. Now you turn around and say that no, modify it.
So therefore,
There is only one problem. As because the account has been paid, you cannot furnish the bank.
You might be having other accounts. Not that this is only.
All the accounts have been paid.
all the accounts have been closed.
What do you say?
Yes, all the accounts have been frozen. Actually, when case is being taken up for investigation, the
Then,
accounts.
property security? What is the amount involved? In property security. Total amount.
Previously, it was ordered to furnish 2 crore.
290.
290.
2 crores 90.
2 crore 90.
The property security of you have to 250. 250. Right. This is an application for seeking modification of order dated 16/4/2025. The land council for the petitioner submits that although the accounts frozen by the investigating agency during the investigation, investigation has been directed to be defrozen by this court by the order dated so. However, subject to the condition that petitioner should furnish bank guarantee of 2 crores. Land petitioner submits that since all the
accounts, that submission may be.
petitioner, all the account of the petitioner has been frozen by the investigating agency during the investigation. Furnishing the bank guarantee is an impossibility on his part. Therefore, he submits that instead of bank guarantee, he would furnish property security of the same amount. The dispute is regarding the disputed the dispute. Where is that figure?
2 crore 9 lakhs.
The petitioner, the allegation against the petitioner is regarding the illegal mining amounting to 2 crores 90 lakhs 24,702 rupees. 702 rupees. In view of the statement made by the council for the state submits that indeed all bank accounts has been frozen. Regarding it to the submission made at the bar and the reasons stated in the application, the order dated so is liable to be modified. Accordingly, the same is modified. The petitioner is directed to furnish property security of 2.5 crores in place of furnishing 2 crores bank guarantee on furnishing the property security to the satisfaction of the investigating officer. Satisfaction of whose satisfaction?
Satisfaction court date. Satisfaction court.
Investigating agency.
Investigating officer. The satisfaction of the investigating officer.
Temple, Jagannath temple.
Jagannath temple administration. To the satisfaction of Jagannath temple administration.
The same shall be communicated to the.
To be communicated to the investigating officer. The bank accounts, all the bank accounts as reflected in the para 9 of the order shall be defrozen. Shall be
2 crore. 2 crore
Property security was that.
property security. Therefore, I'm
2 crore 50 lakh.
yes,
Property.
yes.
68 type.
Typo. Forgive it. Typo.
69.
My lord, in the order of IA 361 of 2025, inadvertently typographical error, paragraph 3 of the order contains a repetition of the conviction and sentence details from 2 different cases, my lord.
Order dated 25/3 ଦୁଇଟା paragraph 3 ନେଇଛି ଫାର୍ଷ୍ଟ paragraph ଟା ସେମାନେ କହୁଛନ୍ତି delete କରିବାକୁ because it is relates to CRL 361 ଅଛି।
Which paragraph?
Paragraph first 3 paragraph number 3 first 3 ଦିଟା
Admit.
ଦିଟା 3 ଅଛି। 361 ଅଛି ସି ଅଛି କେତିକି ଅର୍ଡର ରେ ଦିଟା paragraph ଅଛି 3
हाँ
फास्ट पैराग्राफ टा डिलीट କରିବାକୁ ପଡୁଛି କାହିଁକି ନା ସେଟା ରିଲେଟ୍स ଟୁ सीआरएल 361
हाँ ये देखो ये क्या कौन किया है इसको?
सेकंड टा एंकर
also ये जो order dated तेरे paragraph 3 अच्छी the appellant petitioner has been convicted ये paragraph का delete है that's all.
Grateful,
Okay.
my lord.
Okay, delete. Inadvertently, this paragraph has come on the court, which is come on the order dated also. Delete for the right. Yes.
Item 70.
Typo. Okay. Correct. Correct कर दूँगा. ठीक है?
Item 58. I would not be there at the time of call.
Corrected.
Name is to be changed. Name of the council is to be changed.
Yes, I've done it.
Aju.
Yes.
This item 50, the first item on the orders, your lordship, modification.
Everything has been done, sir. Nothing is rejected. All allowed.
Data ये थिला तो
All allowed. Yes. 3 rule. Yes.
SLC.
The strength of NBW. He was arrested on 16/4/2012.
Sorry.
On the strength of NBW, my lord, petitioner was arrested on 16/4/2025. And earlier he was on a bail.
16/4
2025.
25. NBW
NBW issued on, my lord,
2012-2024.
20
2012.
20/12/24. Bail order. Where is that bail order?
Bail order, my lord, I have filed the affidavit.
A prisoner is accused in 2028 and he was admitted to bail. Which court had granted bail?
London Additional Session Judge Kodola.
The additional session judge Kodola, by which the order
BA number 305/2020, order dated 11/12/2020.
11/12/2020, the additional session judge Kodola had enlarged the prisoner on bail, but due to consistent absence from the court, the NBW against the petitioner on 20/12/2024. Pursuant to the execution of NBW, he was taken into custody on 16/4/2025. Since then, the petitioner is in custody. Regarding to the fact that the petitioner was already enlarged on bail and so on. And affidavit has been filed, he was taken on the court. Yes.
Item 4.
And here are the two. KPN import, Bangalore KPN. Yes.
Item 4, my lord.
Yes.
This petitioner is in no way connected with this case. The allegation 310 to my lord. Document
310.
10. my lord.
DNA.
The present petitioner.
ଟିକେ ରୁହ ମୁଁ ମାନେ ମୁଁ କହିଛି
अरे मोर ये
ସାର୍ ତିନିଟା ମାତ୍ର ଆର୍ଜେଣ୍ଟ ହେଇଛି ଅଲଗା କୋର୍ଟରେ
अरे मोर नहीं
30/6/2025 ତ ଆର୍ଜେଣ୍ଟ
मोर नहीं
Lordship, the accused of this case, in other court, it was adjourned to 30th
No,
June
my
2025.
is the
And
fact
this
case.
is the phrase
It is
case
a
of
face
the
case.
accused.
Face case where I have not named in the charge sheet.
Let me understand what exactly has happened.
No, no, while I am submitting.
ଆପଣଙ୍କର ଗୋଟେ କେସ୍ ପେଣ୍ଡିଂ ଅଛି ଆଉ
Case ନାହିଁ. Face case ଟା.
he says that the same accused.
Other question.
ଆପଣ କୁହନ୍ତୁ.
Other co-accused persons, your lordship, other matters are have also come, your lordship may see noting. Matter is adjourned, other co-accused persons matters that has been adjourned by coordinate bench, 30th June 2025, CDL.
Lordship kinds.
Okay.
In these
Lordship
cases,
kinds.
it is
Three
not
persons are released.
Well, that's right, but if the co-accused person's application is pending before some other court, I can't take it up. Propriety doesn't demand that.
Lordship kinds. So those were principal accused, they have been released. My name does not appear in the charge sheet.
That's right. That's what you are saying on merit. But since because of the noting, if there would not have been any noting, I could have done it. If by knowing the noting that somebody, some other court is hearing, I can't preempt those orders.
About TI parent.
Yes.
No recovery.
Absolutely right. You are entitled to bail. But what to do?
Lawrence Senior's case, ଯଦି ଗୋଟିଏ ଏଇଟା ପୁଣି ଦିଅ ସାର୍ ଘର ସେଥିରେ କିଛି ନୋଟିଂ ନାହିଁ
I'm prejudging the issue which is pending before someone.
ସବୁ କୋଏକୁ ଯାଇଛନ୍ତି
Lordship, visualize my credit.
Since, let us maintain propriety. Since the application for co-accused persons are listed before the coordinate bench on particular day. And CD of the case has already been called up to maintain judicial propriety. I feel it appropriate to leave the matter along with getting bail or not is not more important. Propriety is more important. Yes.
Item 5.
Under offense also 103 of BNS. 103 of BNS.
CD call. Okay.
Item 6.
Item 6, Lordship has granted bail to two persons, and for two persons, Lordship has rejected and say that let them renew their prayer after examination of the witness. So witnesses were examined. Let me file the copies of the deposition so that it can be heard after vacation.
Okay. The earlier the bail application of the petitioner rejected, but order dated our liberty is granted to the petitioner to renew the bail plea after the
examination of witnesses.
Examination of vital witness. The witnesses have already examined. Mr. Mishra submits that he would place on record the evidence of those witnesses. Release the matter on 19th of June. 19th of June. Okay. Or will you move it in vacation?
No.
I'll give.
I'm not there in vacation.
Okay.
Item 7.
Well, item 7. This is the 164 statement of the jury. Lordship may kindly have a glance.
I am appearing on behalf of the reporter.
Custody since.
Kindly have a glance.
No, tell me the custody.
Yes. I am custody 16/4/2025.
Yes.
Tikke खाली 164 statement देखो से कौन कही जे जमी किनिया पे पैसा देली वर्तमान पैसा मते फेरे देले मु तांगा नारे मिछो केस करथिली वर्तमान केस करिया को चाहुनी. This is the 164 statement.
So the
And I am inside custody.
similar 164 and he has clearly stated that mature rape case ditili. I think he should
Again, are you serious?
She should be prosecuted.
The petitioners are having similar antecedents before.
I am not interested. If a false case, 376.
No,
In 164, you see.
This is your 164.
Don't aggravate it. Better stop it here. Let him go out. Petitioner is accusing so against the petitioner so. During investigation, the statement of the victim prosecutory has been recorded. Who is stated to be 48 years of age. She in her statement has stated that the petitioner has taken rupees 5 lakhs.
पैसा कौन नहीं था जमी दे
5 lakhs. Promise of giving promise of
giving him a land, giving her a land,
getting a piece of land in his favor. Promise of कौन लिखा है जी मु सब
पढ़ दूना सेटा के मत क्लियर पढ़ दू
आजिली समय भाई मते पहिला गत 2 मास तळे मते डॉक्यूमेंट धरिकी आसीबा पई कहले जागारे मो नारे 5 लाख टका पई दस्खत मोटर मिछर नै मु तांकू उठू 5 लाख टका नेइची करी की दस्खत मोटर मिछर नै
ଏବେ କିନ୍ତୁ ସକାଳେ ତ ସଞ୍ଜୟ ମତେ ମୋର ପଇସା ଫେରେଇ ଦେଇଛନ୍ତି ପଇସା ନ ପାଉ ମିଛ ରିକ୍ୱେଷ୍ଟ ଦେଇଥିଲି
petitioner no statement that the petitioner has
petitioners
asked forcefully got papers signed from her stating that she had taken 5 lakhs. Subsequently, the money was paid back. She has also stated that since the money was not paid to her, she has falsely filed the case under Section 3. Falsely lost the case. Reading of next one, reading of the statement of the victim under recorded under 164 CRPC clearly reveals that the case is posited against a false case is posited against the petitioner.
Petitioner's murder.
Petitioner
Who-
is
who
in
is-
custody since 16/4/2025 in 25. Regarding head to the statement of the shown to appears for complainant and of the bail. Insofar as the recording of the statement of the statement of the prosecutory under 164 is concerned, the state council has not disputed the same.
That is available in CD.
As the same is germinating from the CD. Regarding to the period of custody and nature of litigation granted. Yes.
Petitioners haba aja.
Petitioners.
Aja.
Petitioners haba, yeah.
Di jana. And accused or sango.
Yes.
Item 8.
May I please, Your Honor? My lord, alleged under section 20B II big B of the NDPS Act, my lord.
It is key because 23 kg.
No, my lord, I am showing that page 18, my lord, of the SI has lost the FIR as per the allegation that he had and go to the hotel number 503 and in the second part of the page 17, my lord, it is the statement of that. Thereafter, as per my the direction, the weighman bag conducted weighment of the carry bag of the accused Suman Kumar and found 2 number of small polythene packet worked with brown jury tabs inside the carry bag of accused having weight 5 kg 33 grams, my lord. And similarly, 2 pocket from exclusive possession of the accused Rajiv Kumar, weigh of the block quantities of ganja rupees 5 kg 63 grams, including carry bag, my lord. It is the consensus.
That is both the accused persons.
Both the accused, 7 number of.
5 numbers of again 5 numbers.
Total bed count of accused were
2 pockets of yes.
Total as the.
5 numbers of packets and containing 5 kilos and 2 numbers of containing 2 kilos. 23 kilos. Charge sheet filed, everything
No.
filed. That is not filed. Okay, get updated Shri.
24/4/2025.
But you will get the bail after vacation only. Issue notice. Call for updated Shri, leave the matter on 20th June. And in the meantime, the counsel for the state to verify the antecedent of the petitioners. Yes.
Item 9.
Obliged.
20th of June. Yes. 20th.
64/1
376.
corresponding of 376.
No,
CD.
Call for CD, issue notice.
Notice क्या बनेगा? आता खाओ only 376. Post को नहीं.
Post नहीं.
नहीं.
Okay, notice करेगी 19th or 20th.
Notice जीवन नहीं है.
20th पे रखियो ना भी.
हाँ, और
20th. If I will not give the date, it may not come. That's why I'm giving the date. Yes.
Item 10.
Call for CD.
Lordship, even if date is given, it is not.
That will come.
ନାଇଁ ଆପଣଙ୍କ ପାଖରେ ଯୋଉଟା ସବୁ ଆର୍ଜନ ହେଇଥିଲା 15 ତାରିଖ ଆଜି ଆପଣଙ୍କ ପାଖକୁ ଆସିବାକୁ ସେଗୁଡା କାହିଁକି ଆସିଲାନି?
No, this is a kind of a special drive, I tell you. Special drive in the sense, before vacation, lot of bail applications were pending. So it was decided that every court should take couple of matters.
Tribal offense ଗୁଡାକ ଆର୍ଜନ ହେଇଥିଲା 15 ତାରିଖ ପାଇଁ ଆଜି ସ୍ପେସିଫିକ ଆପଣଙ୍କ କୋର୍ଟରେ
So it will go to the assigned bench.
ସେଟା ପୁଣି ଛୁଟି ପରେ ଯିବ।
That I can't comment on.
4-2 postponed is there.
Item
10.
Notice. Yes.
Your Lordship, kindly see.
Notice. Also, yes. Call for yeah.
My lord, yeah.
And Foxo नहीं रहती through IO. That through IO.
My lord, the petitioner father is the informer. He admit that they living together as a wife and husband. As per
Once
your Lordship order.
Foxo Act is involved, then notice is mandatory. Without that, you can't.
Yes.
That way you may have a case. Shall I indicate that in the vacation you will move?
Yes.
Right. On vacation, notice, call for record, and petitioner is granted liberty to move before vacation.
Obliged.
Yes.
11.
Wait, please, my lords. The petitioner has been charged sheeted under section 302, my lords.
302? Yes.
The petitioner is in custody since 8/5/2021, my lords. And as per this honorable court's last order, the trial was expedited and to be completed within a period of 3 months, my lords. That is at annexure, my lords. Annexure 4, my lords.
Yes. 4.
And yes, my lords.
Yes.
And in that particular case, this honorable court had directed that only one of the eyewitnesses has been examined and other eyewitnesses were not examined. But in the meantime, all the eyewitnesses have been examined and they have turned hostile. The depositions is under annexure 3.
Show me that.
Yes, my lords. Annexure 3.
Yes.
Yes, my lords. All the depositions.
All of them have turned hostile.
All the eyewitnesses have turned
All the eyewitnesses?
Yes, my lords. One is Gyanaranjan Mahanti, my lords, that's a deposition witness number 7.
7.
Yes, my lords.
Yes. Page number?
Page number 33, my lords.
33.
Yes.
Okay. Read it.
34, my lords. 34.
34, yes.
Yes.
34 is something else.
My lords,
where is your deposition? 30? Okay, 33. 22. Yes. 22.
My lords. So page 22, my lords. Due to some mistake of it. Gyanaranjan Mahanti, my lords. I do not know the informant. I know both the accused persons standing in the dock. I know the deceased. On the alleged date, I was at the drug addiction center. I was admitted there prior to 3 months back. So to de-addict myself, the accused persons were managing the said institution. Total 35 inmates were present. The deceased admitted at to de-addiction center prior to 2 months back. The deceased died at this area. This is because of fits, my lords. All the persons suffering from fits.
Fits. He is not turned hostile.
No. This one has not turned hostile, but this person has specifically said that person was suffering from fits. And due to some cardiac problem, the doctor has also been deposed and the doctor has given that it is a case of cardiac arrest.
Where is that?
That is at...
and what else there? You tell me.
Annexure 6, page 36.
He was an inmate.
No, the petitioner is the...
no, who is PW7?
PW7 was the inmate, my lords.
Was inmate.
And subsequently also.
I was at the drug addiction center.
Yes, ma'am.
It has happened in drug addiction.
He was there as an inmate.
You are also an inmate?
No, I am the managing person of that institution.
Okay.
But
doctor says cardiac arrest. And this witness inmate, he is also saying that
fits. We were suffering from fits.
Fits.
Yes, sir.
6 months direct. Within 3 months, 3 months. That is also not done.
4 years already in custody.
Okay, but and what else, sir? You tell me.
Malats, all these facts, if
and the rest of the witnesses have.
Yes, Malats. If your lordships also see other witnesses, they have stated the same thing.
Which witness?
Malats, we'll go one by one.
No, don't read. I'm not deciding your case on this thing. I'm not going to acquit you.
Not
tell me overall.
These all are eyewitnesses, Malats. If your lordship sees deposition witness number 8, Pratap Barik. 154, he turns hostile, Malats. Standing in the dock, the deceased died at de-addiction center. I remained at the de-addiction center for a period of 3 months. The accused is the associate of Raj Kishore Das in the said center. I was examined by the police, then turns hostile. Then the next, Satyanarayan Barik, page 26, my lords. Doctor, Annexure 6.
You come to PW10. Read para 2.
Yes.
Para 2.
Yes, in the center.
Read 28.
Yes.
Page 28.
Yes, ma'am.
This
Deceased died at de-addiction center,
and the center
Chester.
we
In
were
the center
given
were given with 12 steps for remembering. Accused away from the spot in the Honda Hornet motorcycle with all the papers machine by locking us from the outside and
CCTV machines by locking us
Yes.
from outside and by threatening us not to disclose before anybody. And thereafter, we all inmate escape by breaking the lock of western side of the door under the staircase. I am deposing falsehood at the instance of the accused person.
in the de-addiction
Jata file is
in the de-addiction center we were
file
provided with all kinds. There
just
was
check it
no-
up. Check it up. I think he's entitled to bail.
Yes.
Check it up. At least during vacation. Write down. Write like this. Earlier the petitioner approached this court by filing BLABL number 6141 of 2024. The coordinate bench of this court, although dismissed rejected the bail application by order dated 21/1/2025. However, directed to expedite the trial and directed to conclude the trial within 3 months. Subsequent thereto, how many witnesses examined? 10.
Out of 29, 22 have already been examined. All
Out of
material
29
witnesses.
witnesses, 22 witnesses have already been examined.
And they are the
And
material.
counsel for the petitioner has pointed out that the prime vital witnesses, namely PW 7, 8, and 10, have not supported 8 and 10, and PW Doctor
Doctor is PW 22 man.
22 have not supported the prosecution case. Rather, conjoint reading of the testimony of those witnesses reveals that the deceased has died out of died natural natural death. It is not an homicidal death. Homicidal death. Counsel for the state, however, submits that the deposition copies which has been placed on record is complete. He wants to study the same. Leaves the matter on vacation, the first week of the vacation. First week of vacation.
Deep reflection.
First week of vacation.
Deep reflection.
Item 12.
And just see the sequence, because there is something missing. Otherwise, you are entitled to bail. And
copy also.
Yes. But he is entitled to bail. It looks like the petitioner is in custody since 8/5/2021. In that view of the matter, leaves the same before the vacation bench in the first week of the vacation. First week. Yes.
May I please ask? 12 case matters. 4 kg of ganja recovered from the possession of the petitioner matters.
Sorry?
While there is transferred the ganja near motorcycle matters, only 4 kg of ganja matters. And it was
4
kg.
only 4 kg.
Yes, matters.
Custody?
Custody since 34, 95 matters. 30 25.
30 25.
Well, petitioner has one similar incident matters. The
No,
petitioner has
that's the problem.
one matters, one similar incident.
One is not enough. 37 operates.
The below.
37 operates.
4 kg ganja, that is below.
Have you said that somewhere?
Yes, matters. Para 5 matters.
Subject to verification, I'll grant, but subject to verification.
No, only one. That's
You convince the court.
similar type of.
But 37 operates, then I'll have to reject.
No. The second case, no plans.
Second case, wait. First case. There is no criminal antecedent. Petition is the first time of the review. In so far as the second one is first one.
Only one matter. That's I have mentioned in the para 5 matters.
Afid Dungriya.
Yes, Dungriya. Dungriya.
But Afid Dungriya, na? What are the address?
Well, belongs to matters. Simil further yes, Manmunda.
Both. The petitioner has one criminal antecedent. The state to verify the same report. Release the matter after vacation, immediately after vacation. Yes.
13.
They are antecedent I am granting.
Yes,
they are antecedent verify. Okay.
4 kg ganja.
Yes.
4
kg ganja. No antecedent.
Correct. Custody,
Custody 1/5/2025 में.
1/5/2025, 4 kilo of ganja, no antecedent. Yes. 14.
Oh, sorry. There may not be petitioner is a 22 years old boy.
Allegation.
Indicated on- Offense is 109 along with other offences, my lord.
Yes.
Languishing in
Custody
custody
since-
since 16/4,
16,
16/4/25.
25.
25, my lord.
Yes.
Young boy of 22 years. And young boy of 22 years, my lord. This is the incident, my lord, happened all of a sudden while the victim as well as the informant as well as the petitioner along with others. He was not named. They were coming from opposite side in a bike, dashed, my lord. That is why this has happened.
There is no assault.
Assault part is not there. And in the meantime,
Huh?
Assaulted in Delhi by means of a Bujali.
Bujali.
no, my lord, that is not there, not Bujali.
Like paper and the informant victim.
In the
You are
meantime,
for informant.
And the, to avoid exaggeration or aggravation of the matter has been amicable, which is emerges from road buzzing.
Road rage.
yes,
Road-
no, my lord, on the date of.
Injury, nature of injury?
Very simple. Very
Simple.
He is out of danger.
No, whether it's simple or not. Maybe
Yes, my
also.
lord, it is simple.
How, where from you got it?
The informant is appears, my lord, and file an affidavit.
No, simple means merely because he discharged doesn't mean that simple.
On the same day, just on the day of Hanuman Jayanti.
Do you have an
my lord.
affidavit? We have an affidavit.
Yes.
On that basis, I'll write.
Yes, sir.
Petitioner is accused so, allegation against the petitioner so. The reading of the allegation is a case of road rage. Court case of road rage. Petitioner is in custody since 16/4/2025. Mr. Das has entered appearance for
Road buzzing.
complainant and has filed an affidavit. Complainant of the injured and filed an affidavit inter alia stating that the informant of the injured has entered into a settlement with the accused petitioner, and he has no objection if the petitioner is enlarged on bail. The relevant part of the affidavit reads as under para 2 to
3, 4.
245. 245. Regarding head to the fact that the petitioner is in custody since 16/4/2025 and he is a young man of 22 years. Parties have entered into a settlement and specific counsel for the petitioner on query from the court specifically submits that the injuries are simple in nature. I'll put it on.
And now, my lord, out of danger. Out of danger.
I put it on.
Out of danger, my lord.
And the victim is out of danger. Out of danger, obviously,
No, my lord.
is filing affidavit.
On
in
the same
court.
day. Yes, yes.
And
Yes.
she was the victim was discharged from the hospital after a primary health check and first aid.
Yes.
First aid. तापर लिख दो. Yes.
Great.
15.
15 lakh into law. My lord, on the basis of the mother of the victim, FIR is lodged and case registered under section 137. 137
and 87 corresponding to 366.
My lord, what is happened in this case?
Victim
My
is
lord,
a
may kindly have a
minor.
look to.
Victim is a minor girl.
Minor.
Discretion is there, but for the lordship,
Show me.
anticipatory bail has been granted.
Show me.
Same district, another jurisdiction of highest. Same offense. Same identical incident.
112(2).
Yes.
114.
Organized crime.
Organized crime.
That has been newly added to
And another also BLF was arrested in the spot, in same case, also released on bail.
Same case.
The same case, identical case, same case means that case. Same case, जो case का देख.
What? How many antecedents are there?
Antecedent नहीं, 23% more the instruction है.
Depend must have been there because of that 100 to 111 4 has been
Ah, that's the problem.
organized.
But what he says is,
जो
in
court
this
नाटे-
case, anticipatory bail is granted.
Anticipatory bail है क्या antecedent को था?
Different case, but the offense is 112.
The coordinate bail has granted.
111 4.
Here
Yes.
8,225 rupees have been seized.
हाँ secretary भी list कीजिए दीटे जंग arising out of same case.
Not same case. Why are you saying that?
My lord, the regular anticipatory bail and regular bail which I have passed on now, that is a one.
If these people are co-accused with him,
No, my lord.
why do you say same case then?
My lord, I have given 2 bail application order.
No, where is that? And the other one just you.
The other same case.
Same case means co-accused.
No, the accused of that case, not my case.
Obviously, in this case is granted and showing this, the other guy has got it in that case. But your case is different.
My lord, the offense is same, very identical incident. That is, that for that reason I am showing you false kind perusal. The coordinate was granted with 438. The same district, same area.
I'll grant bail, subject to verification. Subject to verification, you will be released. Okay.
Subject to verification. I
Obviously,
understand that.
no. If you are, it's an organized crime. I am granting you bail. That's all. Not beyond that. Write down. Petitioner is accused in so-and-so, allegation against the petitioner. Petitioner is in custody since 22/4/2025. Then counsel for the petitioner has handed over order dated 1/5/2025, passed in BLAPL number 2780 of 2025 by the coordinate bench in another case of similar name. Another case of similar name. He submits that the facts of that case and the facts of the present case are exactly similar. For ready reference, for the convenience of ready reference, he has pointed out para 4 of the said order, which reads then para 4, so. He further submits that relying upon the aforesaid order for the coordinate benches, the co-accused in that case has also been enlarged on bail, enlarged on anticipatory bail. Hence, he relying upon the order of order. 1/5 anticipatory bail. He further submits that the counsel for the state opposed the bail on the ground that these are crime, and there is nothing coming to the fore on the record regarding the antecedent of the petition. Regard being had to the nature of allegation and the period of custody, although I am inclined to enlarge the petition on bail, however, subject to verification of antecedent regarding the similar case.
May I pray one thing?
Yes.
If some antecedent is there because they are the
Similar case, I am saying similar.
I cannot say antecedent. So its lordship may impose some additional condition if there is there.
Let it be like that. Yes,
Madam?
next.
Okay,
Otherwise, I'll have to issue notice, get it verified, and you will not get bail. What do you want? I'll have to verify. Because these are organized crimes.
Yes.
Yes.
20. May I pray your lordship kindly had taken after vacation.
Okay.
I call for the CD also.
Call for CD, issue notice, call for CD, leave the matter after vacation. Yes.
21.
Obliged.
Only allegation illegal possession of country-made gun, country-made rifle.
Country-made?
Handmade rifle. Handmade country rifle.
That's much more dangerous. That may kill the other side and may kill you also.
Only
It may fire back.
Only possession.
That was recovered from.
Antecedents?
No antecedent. You're not saying now.
I'm
First time it is coming.
Custody since 11/4.
14/5 ଫାଇଲିଛି ଆଜି 5 14/5 ଆମେ ପାଇଲୁ 15/5 ଆଜି କେସ୍
Only possession.
Custody since
11/4/2025.
25
25.
arms expired. Petitioner is accused and allegation is the petitioner from from the custody of the petitioner, a country-made pistol has been recovered, isn't it? Single pistol?
Country-made rifle.
Rifle. Country-made rifle has been recovered from one. Therefore, the case has been registered against the petitioner under Arms Act under section 25(1)(a) of Arms Act. What is the sentence? Arms Act?
Minimum 7 years, maximum 14 years. Purpose of for hunting, for the purpose of hunting.
Hunting.
Yes, my lord. It mentioned in
The serial number.
5th line of the FIR, 6th line. Handmade country rifle in his house for the purpose of hunting as well as to terrorize people.
Oh, terrorize people is also there.
That has
Hunting, terrorize.
normally it was for hunting, but the interior area of the Kalahandi.
hunting allowed to do.
So, he is in custody since 11/4/2025 and subject to appearing before the IIC. Which IIC?
Milo.
Emrampur IIC.
Yes.
Every Sunday at 10 a.m. to 12 noon for 6 months without fee. Non-appearance before the police station as directed shall entail.
May I pray till submission of charge sheet?
Cancel, please.
Till submission of charge sheet, may I pray?
6 months.
Okay.
At least you should be guarded once you go to the police station.
22.
May I praise your lordship?
Okay.
Excuse your lordship. Same.
On behalf of the informant.
Is in custody your lordship since 2 years, 7 months, 19 days.
Can you give the date?
Yes, your lordship. I have already mentioned your lordship.
Yes, what is the case?
My lord, case number
Give me the date, ma'am. I will not read.
29/10/2022.
29/10/22. What are the allegations? Let us see.
395.
My lord,
395.
395/25/27, the Arms Act, my lord. And there is no supervening circumstances, already bail is rejected earlier, my lord. And in the meantime, out of 14 witnesses, 12 witnesses already examined, 2 witnesses left to be examined. And the trial will be concluded within 1 month, my lord. And my lord, there is stringent evidence against the present petitioner. And allegation is that, my lord, early in the morning, my lord, the present petitioner along with 5 others, they entered inside the house of the informant and taken away cash of rupees 18,50,000 and 1 kg 400 grams gold at the point of revolver, my lord. It is a highlighted case in the Kotak city, my lord, in the Manas Vihar.
Okay. Yes.
Certain persons were involved, your lordship. This is all, they were together. This particular petitioner, your lordship, there is no antecedent also, your lordship. No antecedent. He was there. But the TI parade also, your lordship, the person who, the informant, he has identified, your lordship. But the teacher who was in the house, who was taking classes, she has neither been a witness nor she has in TI parade also she has taken part, your lordship. So there is no.
Show me the testimony of the witnesses, those who have.
Yes, sir.
PW12 mile, he has identified in PI period as well as in the court also.
Then
Madam, question is there.
PW12.
PW12 child witness, your lordship.
Whatever that is.
Yes, your lordship.
You could not influence the child witness.
No, your lordship, child with photo uttaji.
Let us get the status up from the trial court when the trial will be concluded.
Whatever has happened.
Total witnesses, how much?
Out of 15,
12 are over, your lordship.
Right. Petitioner is in custody since 29/10/2022. It is submitted at the bar that out of 15 charge sheeted cited witnesses, 12 witnesses have already been examined. The counsel appearing for the informant vehemently submits that the trial is likely to be concluded within a month or so. regard being head to the statement made at the bar, I am inclined to direct trial court to submit a report disclosing the status of the trial and the likelihood of conclusion of trial, the timeline for conclusion of the trial. Links the matter during the first week of the first part of the vacation.
My lord, the vacation, my lord, this court is not functioning, my lord.
This court, the other courts are functioning. Don't worry.
Yes, second half, my lord.
No, report. They give about it.
Yes, ma'am.
Connected matter.
Let it come.
Yes, ma'am.
Fresh report will come and the vacation, first phase of vacation.
Yes.
It will be,
Obliged.
yes.
23.
May I please, my lord? The petitioner is accused to have committed offence under section 109 BNS, read with section 9 IE Act and 3 and 4 ES Act. In the
Custody from which date?
11th March 2025. And court has been released on bail. 11th March 2025.
So issue notice, call for CD. Please the matter of application. Yes.
24.
And I'm on BC. 7 kg of ganja, custody from 29/4/2025.
Just see. 7 kilo.
Yes, my lord.
7
7
kilo.
kilo, my lord. Yes, my lord.
And custody from
29/4/2025.
25, huh? Antecedents?
No antecedent, my lord.
No antecedents. Subject to verification. Yes.
Obliged, my lord.
No.
May I please ask?
9.
Madam, 20B2 C, madam.
29.
Quantity of ganja is
34 kg.
34 kg,
500 grams.
Sorry?
34 kg, 500 grams.
And belongs
Call
to state
for,
of
call
Bihar.
for, call for CD, issue notice. Yes, next.
Belongs to state of Bihar.
Now verification of the address of. Yes.
26.
May I please, ma'am? Here petitioner is the husband. Offence under section 103, 55, 80 and 85 of the BNS, my lord.
What is that corresponding? 302.
Yes,
Issue
madam.
notice. Issue notice. Call for CD. Informant so and so entered evidence and file work not take it on record. Call for CD. Yes. Yes.
27.
Section 4 of the POSCO Act is there.
No, issue notice. Issue notice. Yes.
28.
Through IIT. Yeah. Yes.
20 May, please, lordship.
762N.
Lordship, initially FIR was under section 498A and 34 IPC. Subsequently, it has turned to 3762 and 417, lordship. Subsequently turned to 417 and 3762N, lordship.
376 2A.
2N, lordship. Repeated sector.
2N.
2N.
Why?
Lordship, informant is the
498 FIR converted to 376.
37.
What is the allegation?
Lordship, petitioner and the informant, lordship, they were in a love relationship. Subsequently, they have married. They were living together, lordship. But there was a difference in the opinion, and there was quarrel among them. Hence, at the behest of the family members of the informant, this case has been hoisted against the present petitioner, lordship. Both are the husband and wife living together due to some disturbance in their marital life. This case,
the FIR was registered in 2018.
lordship.
You take
Petitioner
into
arrested-
custody when?
Lordship, 16/3/2025.
There is no
16/3,
marriage, my lord.
25.
There is no marriage, my lord.
Lordship, she has
But
admitted.
see, who is the informant in the FIR?
Wife.
Wife is there.
2018, she says 498A 34.
My lord.
And 2025 were taken into custody. Now converted to 376. Yes. Anything else?
Lordship, no criminal antecedent.
Who is the Pinky?
Let's-
Pinky is the informant.
Lordship, Pinky
And,
Gingria.
why the trial court has rejected? Let us see.
15 is the rejection order. Page 7. It starts from page 17 on the operative portion, lordship.
No, are you sure that this is the FIR?
Lordship.
Huh?
Lordship. Let's see, deposition copy also I'm having it, certified copy.
No, this case is pertaining to this PS case number 48,
The rejection
of 2018.
That to rejection order it is stated also.
They clearly mentioned that they both went to the village Pipilipalli, then Borabada, where they stayed in the house of Sulatupoi for a period of 1 month as husband and wife. They continued keeping physical relationship with her with false assurance of marriage. The accused then sent to the victim to her house to bring her Aadhaar card for the purpose of court marriage, and saying so, left her alone and fled away from the rented house.
What is the allegation in the FIR? Just see.
Let's see, page 12 is the.
Read the FIR.
Let's
There is no case.
Read the FIR.
move Pinky Bigiri. My lord.
Relevant part.
My lord.
विवाह करिछि
Again.
मोर बिना मु सेई पहुंची परिबी नाही
तते छाड़िबी नहीं हमें घर करी चाहि रहबा बोली बाध्य करियो
to enlarge the petition on bail according to the granted date. Yes.
29.
Yes, of 376 2 in my lord. CD may be can be called.
Yes, call for CD. Issue notice.
30. May I please along? That here the petitioner was remanded in this case, my lord, on 17th July 2023, my lord. 392 and 34 are. Your lord, the poverty have been
File affidavit. File affidavit give the status.
The lordship may dispose the bail application with the direction to conclude the trial, my lord, because out of 15, 20, the 12 witnesses have already been examined.
Okay, petitioner is accused in fire number so we should understand. The your bail application was earlier rejected?
No, my lord.
The counsel for the petitioner submit that the co-accused persons have already been granted bail by the order dated which order so it. However, the application order dated Saptisi Eko 2025 in BLAPL number 13100 to 2024 by the coordinated bench. The counsel for the state on the other hand opposed the bail. Opposed the bail on the ground that the petitioner has as many as 29 antecedents. And he further submits that out of how many witnesses?
15, 12 have been examined.
15 with charge sheeted witnesses. 12 witnesses have already been examined. Since the trial is at the advanced stage and petitioner has 29 antecedent, I'm not inclined to enlarge the petitioner on bail. However, the trial court is directed to do well to see that the trial is in the present case is concluded as expediently as possible, preferably within a period of 3 months. In the event the trial is not concluded within the period of 3 months, petitioner is at liberty to move fresh bail application before the trial court. Yes.
31.
As the offense point of 20B2C, 17 kg ganja lordship and two petitioner 1 and 2. 17 kg
17 kg 200 grams.
200 bags.
Antecedent.
Petitioner 1 having 1 antecedent, petitioner 2 number having no antecedent.
Petitioner number 1 rejected, petitioner 2 granted. Custody?
Petitioner number 2
custody. Tell me the custody.
25/4/2025.
25/4/2025. There देखो recovery 17 kilo, 17 kg of ganja, and insofar as petitioner number 1 is concerned, he has criminal antecedents. Therefore, the bar under section 37 operates against him. However, insofar as petitioner number 2 is concerned, he is a first time
petitioner was not press.
First time offender. Not press or press. You can renew the bail.
Petitioner was not press. Petitioner 2.
I am not inclined to enlarge the petition number 1 on bail. That seeks to withdraw the application vis-a-vis the petitioner number 1. Insofar as petitioner number 2 is concerned, he has been in custody since 25/4/2025 and recovery is 17 kilo, granted bail subject to verification. Yes.
32.
And to pray for after bail. After vacation, yes.
33. 33, here the petition in custody since 29th March 2025.
29?
March 2025.
Yes.
Allegation that on the date of proclamation, the person, informant and his wife, they had been to medical for treatment. It realized that the motorcycle was stolen from the campus of the district headquarters hospital.
03.
Yes. And in course of investigation, the person was arrested and the stolen property was recovered, gave in Jima of the informant.
17 number of motorcycle.
From three total accused persons are 3 in number. They filed different bail application.
17 motorcycle.
From 3 different persons. So far, motorcycle concern, 1 motorcycle seized from the position of the stolen motorcycle was seized from the position of the petitioner.
How many accused are there in this?
Accused person 3 in number.
Huh?
This is in respect of 1. 2 other applications pending.
And 111 is there. 111 is there organized crime.
111. Okay, so issue notice, call for the CD and verify the verification of antecedents. Huh?
Did incident sir?
Antecedents.
Yeah, did incident sir?
Verification of antecedents. Yes, next.
On instruction stated in para 7.
Very good. Yes. Organized crime. Yes.
34. 34 million 21 kg, no criminal acts.
21 kg.
My level reflected in order for modification of accident. That is go with 9.
But you have crossed the limit.
If say bag
Follow.
Process.
No. If a commercial quantity, I'll issue formal or notice has to go. Issue notice. Issue notice. List it since recovery is only 21 kilo. Release the matter before the vacation bench during the first half of the vacation. First half of the vacation.
First
half of vacation anybody will give. For CD, without CD, if you give commercial quantity, at least notice has to go and call for CD. This is a formality. Formality. Less than commercial, immediately I am guaranteeing. Vacation, first half of the vacation.
35.
May I please, Your Lordship, I'm appearing through virtual mode, Your Lordship. In the present case, Your Lordship, the petitioner has been languishing inside custody since 10/3/2024, implicated under section 420, 419, 467, 468 IPC, Your Lordship. Your Lordship, petitioner is a woman and she is ailing. In the meantime, already 1 year have been elapsed since behind the bar. And the present case, it is alleged the informant and the petitioner executed a sale deed to which the informant paid ₹65 lakhs towards the sale deed for purchase of a flat, Your Lordship. Subsequently, the petitioner did not reflect the EC against which the informant has lost the present case.
Who are you? Are you a builder?
No, Your Lordship. Yes, Your Lordship. I have a company, Your Lordship.
Company.
No, there is no criteria, and there is it reveals that the rejection order, the prosecution of prior offense reveals that above the existence of previous criminal antecedents.
How many cases are you have?
Admit, Your Lordship, all the cases are pending before different bench of this honorable court, Your Lordship. There are altogether 3 cases as per the instruction, Your Lordship.
You file an affidavit. You are entitled to bail because you are a lady and all are documentary evidences. And but you file the affidavit.
I will file an affidavit, Your Lordship, with regard.
Yes.
Liberty of to move before vacation bench, Your Lordship.
Liberty is granted to the petitioner to move before vacation bench, and the petitioner is to file an affidavit disclosing number of cases and their status. Let the counsel for the petitioner further submits that the petitioner is a lady, is in custody since 10/3/2024. Therefore, he may be granted liberty to move to the vacation bench. Sorry,
the brother of the petitioners had love affairs with the deceased in the same village. She fled away with the deceased, and after no, so far, my lord, I am submitting if my lord feel necessary.
02 POCSO,
oh, this is 201. 200 ଗୋଟେ କହିସାରିଥିବେ ମୁଁ ଖାଲି କହିବି that lady married the brother of the present petitioner, and after some days the present petitioner number 2 fled away with another boy of that village. This is the allegation that she that lady known that boy who has taken this present petitioner number 2 mama.
Yes.
All these two are the small brother and of that main accused. Entire family members in custody, father, mother, and the brother who had taken away that minor girl. These two boy and a girl, they are in custody, my lord, more than a year. Sorry, near about a year. And 200, at best 201, because he died in the house. That is the reason. I am
No,
saying.
but since POCSO is involved, I have to issue notice. That is the requirement. That's the problem. Wrong, right, whatever. I don't know.
No. That
may be wrong, wrongly invoked, but I have to issue notice. Okay, I'll just issue notice. They are in custody since?
Near about a year.
Can you give me date?
My lord, 22/6/24.
22/6/24 22/6/24 same জিনিস করব। They are in custody since 22/6/24 liberty granted to
FR and 22 is
call for CD issue notice and তারপরে paragraph লিখ দেব vacation র first half লগাই দেব। Okay, 37
please go.
Notice may issue.
Okay, issue notice.
POCSO is there.
Notice POCSO involved in that. Yes.
38. May I please, Lordship? My Lord, offences are 126 clause 2, 296, 109, 115 clause 2, 351 clause 2, 3 plus
Yes,
5 of
tell me,
BNS.
tell me the allegations.
My Lord, it is a case and counter case, my Lord.
307.
Yes, my Lord.
Injury?
Injury results.
A simple view also.
This is
Multiple injury. Multiple. Custody since?
22/4/2025, my Lord. No,
22/4/2025.
25.
Yes.
There is no criminal incident, my Lord. And actually, my Lord, the injured
How
person.
many of you are there?
Yes, ma'am.
Sapne Kathar.
Yes.
here only
One petitioner.
only one petition here.
Let us see what is the allegation against him.
Allegation is, my Lord, the actually, my Lord, injured person first assaulted the petitioner's father, my Lord, by the ex.
Don't tell your defense. Tell me the allegations.
Allegation is the informant or the affair that the his family assaulted by
What is the
injured
record
person.
from you? Read your allegation against you. This
Number 11. ठीक सेते गोटे स्वप्न कटा दिस पिटिशनर धरिथिबा टांगियारे हठात मोर भाई को जीवन मार
Tangier.
मुंडरे
Backside of
पिटियो एंड फ्रैक्चर होची
Issue notice. Weapon is serious open and head injury. Issue notice. Call for appropriate CD. Release the matter immediately. Yes. 39.
Mr. Sahu, my Lord, 302 matter.
Oh, issue notice. Call for CD. After vacation. Yes. Next.
40 Miller 48 liquor Miller ID liquor from my house.
25 liter here 20 liter item. Two antecedent. One is similar antecedent, another is not.
Order case.
ସେଥିରେ ସବୁ ବେଲ୍ ଅଛି କଣ୍ଡିସନ ମିଲର ଥାନାରେ ଆପିୟର କରିବ ଆଉ ମଦ ଫଦ ବିକିବନି ଥାନାରେ ଆପିୟର କରିଗଲେ ଆଉ ପୋଲିସ ବାଲାଙ୍କ ପାଖରେ ଆଉ
The best place is jail. You are safe there.
No, Miller.
And people are also safe.
ଆଉ ବିକିବନି ଷ୍ଟିଡେଣ୍ଟ କଣ୍ଡିସନ ମିଲର
302 you are involved and similar antecedent.
ପୁରୁଣା କେସ୍ ଏବେକାର କେସ୍ ସେଥିରେ ସବୁ ବେଲ୍ ଅଛି ଏବେ ମିଲର ଏବେ ଇନଫରମେସନ
Notice kare up to date.
ଆଉ ନୋଟିସ ସେଇ ତ ମିଲର ରିଜେକ୍ସନ ଅର୍ଡର ଲେଖା ହେଇଛି ଆଉ ବିହାର ଓଡ଼ିଶା ମାନେ ଓଡ଼ିଶା ଏକ୍ସାଇଜ ଆକ୍ଟ
I know, but the incidents are very serious.
ସେଥିପାଇଁ ରହିଲେଣି ପାଖାପାଖି
I'll grant you bail, but wait.
ରହିଲେଣି ପାଖାପାଖି 2 ମାସ ହେଲା
2 ମାସ not.
ଚାର୍ଜସିଟ୍ ବି ହେଇଗଲାଣି ମିଲର ଆଉ କିଛି ନା ଆଉ ଅଧିକା ବି ଯୋଉ ଲେଖା ହେଇଛି ଇନଭେଷ୍ଟିଗେସନ ସଇଲା
I'm giving you a specific date. 19th of June.
No,
8th,
yeah,
9th.
the vacation ରେ ଥାଉ
Vacation रे. See, petitioner is in custody since
16/4/2025
and the allegation against the petitioner is recovery of 48
liquor
48
liquor of liquor
48 bottles of liquor.
Again.
48 bottles of liquor.
45 liters. 25 liters beer, 20 liters of ID.
Recovery so much. And since the petitioner is involved in two other cases, one of them is the similar kind of case, and the other case is case under section 302. The petitioner shall file an affidavit disclosing the details of those cases and the status of those cases in view of his custody period from 16/4/2025 and regarding head to the nature of allegation and recovery. I am passing that order so that getting bail will be easy. And taking into consideration the severity of the punishment in the present case, it is expedient that the matter should be listed before the vacation in the first half of the vacation. Okay. So that you can show this. You can do something. Yes. 41.
My offense is 20B2I B of NDPC. My quantity of ganja 3 kg 850 grams.
3 kilo. No antecedent?
No criminal antecedent.
3 kilo? 3 kilo 850. Custody period, madam?
27/4/2025.
27/4/25.
Yes, ma'am.
Okay. Yes.
Obliged.
42.
Maybe 3 persons in a car, my lord, and 50 kg is the quantity. It was found in 2 bags.
Total 50.
And I am the owner of
Issue notice again, same thing. Issue notice, call for up-to-date CD. First half or second half? Vacation.
Yes, my lord, please.
Second half. Second half.
Well, my lord.
Second half of the vacation. Second half of the vacation. 43. By chance, I may be there.
Yes,
I can remove. Yes.
52A Odisha excise 150 liters of ID. Near about 1 month in cost.
Sorry, sir?
150 liters of ID. Near about 1 month in cost.
150 liters.
Near about 1 month in cost to 24/4.
Antecedents?
Antecedent जो करता है बेल एंटीसिपेटरी बेल जाइए 2 year 11 जाती हां गोटे एंटीसो कन्फेशनल स्टेटमेंट हेतिला रेडी दिला 50 कम दिला तो ये कन्फेशनल स्टेटमेंट
सेम ऑर्डर
नहीं एटा कन्फेशनल स्टेटमेंट हेति जो
कार कन्फेशनल
ए सेही बेल हेछि सिके एंटीसिपेटरी बेल जाइए गोटे एंटीसे 52 ओडिसा एक्साइज एंटीसिडेंट जो अछि सेटा म हेइ पे आनी आइसे एंटीसिपेटरी बेल ले जाइए सेटा कन्फेशनल स्टेटमेंट हेतिला नॉट कन्वर्स
व्हाट इज द रिकवरी इन दिस केस?
एटा आटू किछि रिकवरी
एक केस रे
एक केस किछि रिकवरी कन्फेशनल स्टेटमेंट
you have proved your crime.
No, madam, that's
You got an emboldened after the incident.
No, not an improvement. Mixture is ता मां को नहीं जाइथिले तो जाइथिला जो एक्सरसाइज थाना को जाइथिला ताको
Call for report. No, call for because you are involved in. See, you got anticipatory bail immediately. Another.
No, madam, एटा हे मु फेयरली सबमिट काई कहूची जे ये जाइथिला त मां ना एलिगेशन से थाना को जाइथिला एक्सरसाइज थाना तो मिस मु हित नॉल मु कहि न था
Where have you said that? Show me in the petition where have you said? I'll record that and grant the bail. Show me. Not observe. You show me. Record have you said that. Orally you can make out any story. You put it in writing. I'll extract that and I grant you bail. Orally you can put anything, cook up some story and tell me.
No, cook up. That is the case.
It has to
confessional statement केम दिला confessional.
Show me the statement.
Is that is the case. Your lordship observe that. Your lordship observe that.
And who that, sir?
Your lordship eta no hoitile mo point mo fairly कहि देली का.
Similar kind of yes. I'll grant you bail. That doesn't mean that
more than one antecedent.
Item that 43. Okay. Petition is accused in so and so case. Custody from
24/4/25.
24/4/25. Custody in so and so. And petitioner is involved, admittedly involved in another case wherein this coordinate bench of this court has granted anticipatory bail by order dated 3C Eco 2025 in ABPL number so and so so and so. Further the state council is to verify the further is there any further antecedent or not, and call for CD since taking into consideration the period of custody and nature of allegation and the fact that in the disclosed antecedents, the petitioner has already been granted anticipatory bail. It would be expedient that the matter should be placed before the vacation bench in the first half of the vacation. Because I have given Mr. Panda is also immediately stand up and say that in my case 48. No, I have to maintain balance. First half of vacation, I have virtually written the bail order, approved and given. Yes. First half, I am giving you deliberately because I know you will get it. I know you will get it. Vacation, see, bail matters has to be heard in any case. 10-15 days re suniya katha. We are not able to hear it. It's an unfortunate thing. Every 10-15 days matter should roll up. So therefore, yes. 44.
22 NDPS Act, my lord. 2 bags, each bag 50 kilo, 2%
Recovery?
from the
30. Same.
Hyundai car, my lord.
Call for CD, issue notice, release the matter on 19th. Yes. 45.
Others matters are fixed to 29/7.
Sorry?
Other matters are fixed to 29/7.
Fixed to 29/7 to
29/7. Listed 29/7. Yes. 29/7. Yes. July. Yes. Connected matters are listed on 29. Lease the matter. Yes.
46.
46, my lord. Offense numbers 69 and 88 of BNS Act, my lord. There is a law of affairs since last 10 years and promise to marry, keeping sexual relations.
Can you show me the 164 statement?
This is the FIR written by the
Complainant.
victim.
What is the age of the girl?
30.
30.
30.
30. Okay. What is your age?
31.
31. Read the allegation.
Fifth line, my lord. ଆଜକୁ 10 ବର୍ଷ ହେବ ମତେ ଭଲ ପାଇ ଆସୁଅଛି।
Sorry?
Fifth line.
ଲେଖି
ଲେଖି ଜଣାଇବା କାରଣ ଏହିକି ଯେ
10 ବର୍ଷ হবে ମତେ 10 years they were having.
ଆଜ୍ଞା।
10 years they were having.
And your lordship kindly
that is supposing that one person commits sexual intercourse with the lady giving false assurance of marriage, then you will be
69, huh?
69. That is the new section 39 in BNS.
Deceitful means.
And he promised to marry without any intention of fulfilling the same, and as sexual intercourse with her such sexual intercourse not amounted to appropriate.
Now it is a special offense.
Yes.
Earlier it was 420 and all, huh?
This has been added.
Added, huh?
Yes, because there are so many cases of this type. Therefore, it has been included. And specifically that promising marriage.
There is a special offense in now.
And offense is, my lord.
And liable which description for a term which may extend to.
And shall also liable to be fine.
Also. And also. Now a special offense.
It's a tribal assistance also.
and in last para, my lord, page 10 say
No. Normal IPC there was no offense. 376 used to be there. But now there is a specific offense. I am issuing notice call for up-to-date CD. Issue notice call for up-to-date CD because it is specific offense now. Yes.
Victim is a major.
Major, yes, sir. See, new act. New Act, 69. Specific offense now.
Okay.
Notice notice. Yes, next.
47. Here in this case also.
46 for the same, it will happen 46 plus your second matter.
I'm just issuing notice.
No, 46 matter, another matter is 46. Same accused was filed earlier. That is to be done with the same cause of action. One person now the two will be better.
Acha, you have already moved an application.
Motor first file is.
Huh?
The second is
Which one? No.
508.
The two application can't be. Which one you want to keep it?
5087.
5087.
87.
Let us counsel 5096. Since the petitioner has already applied for grant of bail by filing a BLAPL number 5087 of 2025, the learned counsel for the present petition 5096 is being a petition filed subsequently is dismissed as not pressed. This is not pressed. Dismissed as not pressed.
Not press, withdraw.
Withdraw.
Yes, ma'am.
Why have you filed two?
No, it was not within my knowledge.
Oh, okay.
At the time filed, only now registered only 3-4 numbers different. So that no.
Okay.
47. May I please, your lord? Here also, my lord, out of 9 charge sheeted witness, 7 have already been examined. The lordship may direct to conclude the trial.
29 criminal acts.
That in that case,
392, 34
my lord, same person in 30 item 30. My lord.
Same. Right on. Okay. Total witnesses.
All these are
total
witnesses 9, my lord.
9.
Seven.
Right on. Learned counsel for the petitioner seeks to withdraw the present petition in view of 9. The petitioner is in custody since
17/7/2023.
17/7/2023. Yeah. 23. And the trial is proceeding at an expected pace. Out of 9 charge-sheeted witnesses, 7 witnesses have already been examined. At this stage, at the advanced stage of trial, I am not inclined to enlarge the petitioner on bail, particularly for the reason that petitioner is involved in as many 29 other cases. 29 other cases. Hence, the petition is granted liberty to renew the bail plea after 3 months if the trial is not concluded within that period. Yes.
48. 48, my lord. Petitioners are in custody since 16/4/25, my lord. 20B2C of NDPS Act, my lord.
Direction for
Yes. 38, my lord. 38 kg of ganja. One bag 18 kg and another bag 20 kg of ganja has been seized from 2 persons, my lord.
Issue notice, and call for the up-to-date CD. Lease the matter. Liberty is granted to the petitioner and move before petition bench. Yes. Next.
49.
Under section 366, 363,
Okay.
376.
Issue notice.
Notice.
Yes. Okay. Thank you.